All right, welcome everyone to the sixth and final webinar in the 2018 webinar series, Unwarrantable Failures, looking at the causes and effects. As always, I am your host, Nick Scala, and the chair of the MSHA practice group at Con Marcial Carey. For those who have been with us before, thank you very much for joining us again today. And if you haven't, welcome, and I hope that you find the presentation today helpful as we look through some of the elements of unwarrantable failures and the repercussions that can follow with them. So we're going to look at a number of different aspects today of unwarrantable failures. We're going to look at the definition and legal authority as it comes from the Mine Act, along with some of the requirements for both issuing and reviewing a 104D. We'll also take a breakdown just of the types of 104Ds, because we just typically say that it's an unwarrantable failure, it's a 104D, but there are actually somewhat three distinct types of the issuances, and each one is a bit different. So we'll look through those. Then lastly, we're going to go and talk about some best practices for avoiding this type of enforcement. And also we're going to look at supervisor liability and maybe some recommendations and best practices on that end. Because unfortunately, if we are talking about unwarrantable failures and we have received one, we are also going to be evaluated for the possibility of and special investigation into supervisor liability. So we will address that as well. So to get started, let's just jump into the meat of it. These are both excerpts that are pulled from the Mine Act or MSHA's materials on unwarrantable failures. So when you go on MSHA's website, if you search unwarrantable failures, you're going to come up with that first statement in the screen. And it will say that the Commission has held that an unwarrantable failure on the part of a mine operator in relation to a violation constitutes more than just ordinary negligence. And that means it is reckless disregard, intentional misconduct, indifference, or a serious lack of reasonable care. And so those should tell us, just to get started, what an unwarrantable failure is. It is going to be a situation where MSHA believes that there was aggravated conduct or more negligence than normal on behalf of an operator. And that can be both on the company as a whole, as well as the individual management personnel, as we talked about with those in special investigations. You'll see that in that bolded portion at the bottom of that first statement, you actually see the term reckless disregard. And unlike the other terms listed, intentional misconduct, indifference, or serious lack of reasonable care, reckless disregard should ring a bell because it is one of the negligence classifications for MSHA's citations. And we don't see it often, and that is because it is a very high bar, but it is nonetheless one of the definitions that we see and that we can be familiar with and look at MSHA for how they define it. And that is when an operator has displayed conduct which exhibits the absence of the slightest degree of care. Now, it is important to note, looking at that you do not have to have a reckless disregard negligence designation in order for MSHA to issue a 104D, but nonetheless, that is the type of negligence they're looking at. Typically, within 104D, you need to have at least that high negligence designation, which means that there are no mitigating circumstances, and you'll be in that realm or the reckless disregard if you are receiving a citation or an order under unwarrantable failures or 104Ds. Also, the second statement is part of the program policy manual. And you've likely heard me talk about the program policy manual many times before because it's a very helpful resource and it provides a lot of guidance. MSHA isn't big on putting guidance out on the website in terms of how they are going to be looking at specific regulations. You don't have as many interpretive documents as you do with, say, OSHA. We used to have the program policy letters. That is a tool that seems to be used less and less by the current MSHA. But nonetheless, that program policy manual, which was put out quite a while ago, addresses a lot of different areas, almost all the areas that MSHA is going to touch on. And they have in there the statement on the bottom, that the Commission has held that a violation is caused by unwarrantable failure if the operator has engaged in aggravated conduct constituting more than ordinary negligence. And that might sound familiar if anyone listening has ever received or seen a 104D citation order, because this bolded part, aggravated conduct constituting more than ordinary negligence, is included at the end of each 104D, or else it should be. It's a type of boilerplate insertion into the citation body, into the description, in order to help justify that issuance. So many companies call me up, and specifically the individual operators, because the statement might say, you know, Nick Scala has engaged in aggravated conduct constituting more than ordinary negligence. And people get worried about that. The 104D has been issued. That is the assertion in the 104D itself, but MSHA requires that its inspectors put that term, or that phrase, I should say, into each section, each 104D. So we're looking at a high bar in terms of negligence. As we said, it has to be at least high negligence, which is the operator knew or should have known of the fault of the condition or practice, and there are no mitigating circumstances. So obviously, as with most instances with MSHA enforcement, especially when we're looking at 104Ds or looking at high negligence, we disagree with the assertion that there's no mitigating circumstances, which can be anything along the lines of training provided, safety actions taken, just exposure to the condition itself. So that's something that we'll talk about a bit more when we look at the factors and requirements. But looking back at this further, the Mine Act also provides the definitions in, surprisingly, Section 104D. And in that, and I haven't included the entire language, but it's talking about what types of situations or violations can be considered unwarrantable failures. And we have here that it's such a violation of a nature as could significantly and substantially contribute to the cause and effect of a coal or other mine safety and health hazard. And if he, the inspector, finds such violation to be caused by an unwarrantable failure of such operator to comply with a mandatory health and safety standards. So what does this mean? You can probably tell from the bolded sections, but this is discussing what types of citations or what types of violations can be considered unwarrantable failures. The first screen we looked at discussed the negligence. As we talked about, it has to be reckless disregard, intentional misconduct or indifference, aggravated conduct constituting more than ordinary negligence. Here we have the additional section that has to be of the nature that it could significantly and substantially contribute to the cause and effect of injury or of a safety and health hazard. So we should all be triggered by that. This means it has to be the initial instance, a 104D1, an SNS violation. So we have to have that initial criteria. And a quick go around on what is an SNS. An SNS is a classification of a violation that MSHA issues. Essentially, this test that we have up here, these 4 points, are from the Matthews Cole case, which decided 4 criteria for reviewing SNS many years ago, and it's what MSHA still uses today, and the Commission still uses when looking at it. But in order for their citation, or a 104D in this case, to be SNS, you must have a violation of a mandatory safety and health standard, a discrete safety hazard contributed to by the violation, meaning you violated a regulation and there was a safety and health issue because of that, a reasonable likelihood that the hazard contributed to or result in an injury, and that the injury would be reasonably serious in nature. So to break that down, the first element is typically checking the box. If MSHA has issued a citation, they likely have a mandatory safety and health standard that it applies to. Now, mandatory safety and health standards for the purpose of being SNS does not include Part 50. It does not include Part 45, which is having to do with contractor logs and other administrative tasks associated with that. And it does not include Part 41. So this kind of skirts around the record keeping. And so this is something to keep in mind. If you ever receive a record keeping citation or violation, that should not be SNS, just based off this analysis at the heart of what a significant substantial violation is. Sometimes you will see those sneak by that an inspector might have it as S&S for some reason, although that is typically unlikely. But nonetheless, keep that in mind. You have the ability to push back because only certain regulations found in certain parts of MSHA's Code of Federal Regulations can be considered S&S. Now, that does include Part 46 and 48 for training, HAZCOM at 47, along with all the substantive regulations in 56, 57, and 75 and 77, to name kind of the highlights. So, you know, it's something to keep in mind, but typically that is a checkbox item on this evaluation. The other, number two, is that a safety hazard was contributed to by the violation. So, did we violate a safety standard, and was there therefore a hazard present? Again, this is usually a checkbox because if we don't have a guard in place, that's a violation of a regulation, and also there is an open moving machine part most likely. That is kind of the thought process. Now, the third element, reasonable likelihood that a hazard contributed will result in injury, is typically where we make a stand from a litigation perspective if we are arguing against an S&S designation. And that's because this is tied to exposure typically. Was there exposure? That is the only way it can be reasonably likely that it would result in an injury. So a bit of a crash course in challenging an S&S, because that is an important part of evaluating whether or not an unwarrantable failure was appropriately issued. Also, the reasonable likelihood that the injury would be reasonably serious in nature. This means if we're looking at a citation that the box checked would be lost workdays or restricted duties or more severe, so permanently disabling or fatal. Again, this is unfortunately typically a check mark on the evaluation because it's hard to argue against any type of injury, even if it's a slip or fall, having the possibility to result in lost workdays or some type of restricted duty. So a quick review of S&S, because a 104D1 has to be an S&S violation. The other factors that are going to be reviewed when we look at an unwarrantable failure, and these come from the Commission, so the Federal Mine Safety and Health Review Commission, that is the FMSHRC acronym up top. They have decided in a case called Consolidation Coal a while ago that there would be several factors that are going to be evaluated when we look at the appropriateness of an unwarrantable failure being issued. And it is not a situation where it's an and or an or. It's kind of a graduated review of these. So if one of them is very egregious with regard to the length of time or the operator's knowledge, that might satisfy the unwarrantable failure criteria, even if the other ones don't really amount to a significant or a very big violation in the minds of the evaluators. So, for example, the Commission is going to look at, when we're talking about an unwarrantable failure, and if it was properly issued, the length of time that a violation existed and the extent. So how widespread was it? Was a piece of equipment defective for a long period of time and no action taken? Whereas the operator placed on greater notice that great care was required. This is typically going to be, were you informed about this at previous MSHA inspections? Or did you receive a high number of citations under a specific standard or in a specific area that you knew that, or under MSHA's argument, you knew that you had to do more to comply and you did not? We might have heard an inspector at one point in time, or heard stories of an inspector at one point in time, threaten this as they issue a citation. Oh, this time the citation's S&S, but if you don't correct this, next time it's going to be an unwarrantable failure. And that is item 2 on this list, where you put on notice that greater care was required. Number 3 is typically a helpful element for us to look at from the operator perspective, but what were our efforts in abating the condition? If we did know about a condition and it was not corrected, did we take any affirmative steps to correcting it? Did we order parts? Did we change work practices to avoid it or prevent this condition from occurring? Had we roped the area off until the part could be in or shut the area down? What items or what actions did we take? This is a very big one. Again, this comes to exposure. So that basic element, that base element in the S&S violation analysis, but nonetheless is still a big element in unwarrantable failure. You can oftentimes mitigate that designation by proving that you had taken some type of affirmative action to protect against the condition. Number 4, whether the violation was obvious or posed a high degree of danger. And 5, the operator's knowledge of the existence. So these two often run together in the analysis, especially in the event that a minor or a supervisor is doing something that is unsafe in the presence of management, or a supervisor is doing it themselves. If that is the situation, you're most likely going to get an unwarrantable failure based off of the operator's knowledge of the existence of a violation. That 5th element is often the most important in this analysis because it is most directly tied to the negligence evaluation, especially because if the operator or its managers knew of the existence of a violation, did nothing to correct it, that is a very easy way to tie back into the unwarrantable failure. The obviousness or the high degree of danger, I will like to use the example of, was someone working nearby out in the middle of your shop or your plant from a height but not wearing fall protection. That is a situation that you constantly see where it might have only existed for a moment in time, but because of the high degree of danger and how obvious it was or easy to observe, it is instantly classified as an unwarrantable failure. So some basic elements there that are looked at when we're making that analysis. Another part of the 104D or unwarrantable failure program or tool that MSHA has is this D chain. And we've likely heard of it or heard it mentioned at some point in time. And the D chain is really the way that the different types of 104Ds or unwarrantable failures work together. So you initially have this 104D citation. It's your first unwarrantable failure, and it is issued. It's S&S. There's high negligence involved at the minimum. And once you receive that, essentially a 90-day clock starts ticking. And this is also from Section 104D of 1 of the Act. And you can see that if during the same inspection or any subsequent inspection of such mine, within 90 days after the issuance of such citation, that being that initial 104D, there can be another 104D issued, and it is a 104D1 order. Now, citation and order are important distinctions at this point in time, and we'll break this down a bit easier in a following slide. But the 104D1 order is a withdrawal order, and you can see that in the bolded part at the bottom. So you now have a withdrawal of the equipment or the area or the person's performing a certain type of task. And it changes. You know, this changes how we do the analysis. When we're looking at a withdrawal order, there is no abatement time frame set up. There is no termination deadline because it is removed from service until approved by MSHA to be put back into service. You know, in a in a landmark case on this topic, it's from Emory Mining case back in 1987, MSHA identified this graduating scale of 104Ds or unwarrantable failures as one of MSHA's strongest tools, and I think it most certainly is, because you get these 104Ds, that first one, and if you don't receive another 104D1 or unwarrantable failure for 90 days during that inspection or any subsequent inspection, you move on. And MSHA has to find an S&S violation with at least high negligence again, satisfying those criteria for unwarrantable failure in order to issue But if within those 90 days of the first issuance you receive another unwarrantable failure, you're now on the D chain. And now, until MSHA does a complete inspection of the facility without finding a single unwarrantable failure, you and your company continue to receive these withdrawal orders anytime MSHA sees a similar citation. So it is a very strong tool, and we are going to call it a three-step process. This point in time, this section of 104D1 is the second item on the list. So you have the 104D1 citation, then the 104D1 order described here, and then next you have 104D2s. And the 104D2 is also an order, and it's a withdrawal order as well. The difference being the criteria to issue a 104D2 is lower than the initial or the threshold criteria for issuing a 104D1. These don't have to be an SNS violation. They just have to be something that is of a similar violation or a similar condition, whether that be the practice or the condition being a guard being off. It can also be similar in the sense that they believe it's open and obvious, and negligence is the most overwhelming factor. But nonetheless, 104D2s are easier to issue. They are also withdrawal orders, so again, you don't have an abatement time frame. You have a withdrawal order on the area until MSHA says you can enter it. So they are a difficult situation to overcome. They're also a difficult situation to move past if you have widespread conditions that MSHA is unhappy with. You will have to have a clean inspection, meaning no 104Ds, and that is how you get off of this D chain. And you can see down at the bottom, if you go through an inspection which discloses no similar violations, so no 104D2s, the provisions of paragraph 1 shall again be applicable to that mine. So that means you go back to section 104D1, meaning you have to have a SNS violation. You have to have aggravated conduct in order to get back on this chain. So let's look at it just kind of an overview of that 104D chain. You first have the 104D1 citation. Then you have a 104D1 order within the 90 days of the initial D1 citation. Now, it's important to know, MSHA is aware of these timeframes just as much as we are. So if you are a smaller operation and maybe you don't see MSHA but for a couple days when they're on site and you get a 104D, I would probably expect them to come back before that 90 days passes, even if they might not usually come back for an extended period of time. Because with that 104D1 citation, you still have an abatement time frame, given that abatement has to be approved by MSHA, but it might be something that can be approved by MSHA when they're on site, and by the time they close out that inspection, the 104D is terminated, and that's fine. But just be aware you have this 90-day time frame, and I would expect them to be back before that tolls. After you get the 104D1 order, any similar violation can be issued as a 104D2, and both 104D1 orders and 104D2 orders are withdrawals. Again, so those shut down an area, shut down a piece of equipment. And as we said, that continues until a full inspection completes. This is similar to the POV, or pattern of violation rule as it exists right now with SNS citations, that in order to get off POV, you have to go through an entire inspection without an SNS citation, although that is a much, much, much higher bar. But you have that reduced criteria for a 104D2, and you can contest a 104D2, you can contest a 104D1, you can contest any of these, but they still shut down your plant immediately, so, or your facility or your equipment. So if you have an issue with a 104D2 or 104D1 that is a withdrawal order, you are probably going to want to be looking at expedited proceedings if you think that the abatement is not feasible, whether that is technologically or financially. But until a judge rules on that, that area is shut down. And working in the face of that order or ignoring that order will result in even more citations and more piling on with the agency. So these are a very severe tool. My recommendation is if you're going through this D chain, you need to aggressively fight the allegations. You also need to do your best not to create a contentious relationship with the agency, but to work with them and offer modifications or offer situations that might allow them to modify that withdrawal order to permit small scopes of work. So, for example, if an area of your mine has a safety hazard that MSHA is shutting it down, this might shut down your entire operation. Maybe they will modify it to allow you to perform a certain amount of tasks or a certain type of task that gets the plant up and running, but doesn't allow you to be in that specific area. Again, it's very fact specific. So to really discuss, how you might get around a 104D in terms of working with the agency to modify it before fully lifting it, you got to look at the individual circumstances, but it's something that you should be pushing for if you haven't already developed and agreed to a abatement time frame with MSHA. Again, unlike a 104D1 citation, a withdrawal order, any action has to be approved by the agency and any correction has to be approved by the agency before you can bring it back into operation. So look how that might be affecting you. In terms of how the citations are different a bit more, if you're looking at a 104D citation in order, a D1, you are looking at a minimum penalty of $2,300. That used to be $2,000. It has gone up now with the Inflation Adjustment Act and continues to go up by a percentage each year. You can have that assessment anywhere between that $2,300 and the $259,000, which is the max penalty MSHA can issue for a reckless disregard or a flagrant violation. If you are not in the flagrant category, your statutory max is going to be just about $70,000 per Part 100.3. You also have the difference then between the two citations. So you have the 104D1 citation, which is the initial issuance, as we discussed, must be S&S, must be at least time negligence, and then has that abatement and termination deadline. So you can just go ahead and correct it how you see fit. It is not a withdrawal order. That 104D1 order, again, it's withdrawal for the area, equipment, or the task, does not have a termination deadline, and the abatement must be approved by MSHA. Again, then we're just recapping where we're going with these. If we are getting a 104D2, that is that third one on the list, the minimum penalty doubles, so around $4,700 per issuance, and it is still that withdrawal. So a graduating scale of enforcement, but it also, I have to keep in mind that once we get to those on 104D2s, we have a bit of a lowered threshold on the issuance. I see that I have got a comment here. Give me one moment. So this is a question having to do with similar violations under the 104D. And it comes back to the question of, does it have to be the same hazard or can it be a different hazard? The argument is that it is a similar standard or a similar condition to that which was experienced or identified previously. And again, the definition, though, of, where is it? It's right here. The issuance, the definition of similar doesn't always mean the exact same regulation. It is not necessarily a repeat violation like there is with OSHA where you have the same standard. The similarity could be the type of violation. It could also be a similarity in the negligence or the widespreadness of the condition. I think there should always be some nexus between those initial violations, but if MSHA believes that the conditions are open and obvious, believes that management had reason to be aware of them, they will venture into the realm of being a bit more aggressive with the D2s and seeing how far they can push it. That doesn't mean that they may not be able to sustain those, but they will try to issue them. Since they're 104 D2, if they are issuing them, there is obviously cause for concern. So it does not have to be the same standard, but if a condition is, again, posing a high degree of a hazard to the individuals or to the area, that is a similar violation to the other ones, it might still apply. Again, I'm not sure how much the individual asking the question wants to share into the specifics, and if you want to touch back with me afterwards and discuss in a bit more detail, I'm happy to, but again, these are always very fact dependent, and I think you're looking at maybe more factors coming into question than I want to address right now. But the similarity of the violation, it doesn't have to be that same regulation. It can be similar in that they are contributing to a similar hazard, or it can be similar in that there was a similar level of negligence. But the conditions are typically related to some extent. You typically don't see it in a housekeeping and then there is a citation of 104D for lighting, or maybe those, you could make argument that MSHA sees nexus based off of the conditions being inadequate lighting, and that contributed to the housekeeping, but you have to look at how closely those arguments align. But again, because these are 104D2, they do really pose a lot of concern because they are that shutdown order. So again, if you'd like to discuss it more, please feel free to email me, but I think that might just be a quick answer to your question. So how are we going to avoid these? This is obviously the million-dollar question, but these are just some best practices. So ensure employees are aware of and follow company policy for the purposes of safety and health. Many of the issues that we see when we get into this area, MSHA is getting especially uncomfortable with the condition or taking more aggressive action against the operator because they believe that what was occurring was in a known violation of their own policies. Therefore, they were on notice that greater care was required, meaning they had already procedures in place. So make sure your people are aware of and follow your policy. Audit this policy, okay? Make sure people are following them. And if there is noncompliance, you have to enforce that, and you have to formally enforce that against all your personnel. Now, MSHA is a strict liability statute. We don't have the ability to argue unforeseeable or unpreventable employee misconduct that we do during an OSHA inspection or a citation. But nonetheless, that's considered a mitigating factor. So and it goes to negligence, which is an essential element here, right? So if we are going to perform an audit and correct our personnel, we provide that information. Hey, look, MSHA, we are proactive here. We make sure our people follow our regulations, and if they don't, we correct it. We also want to quickly take action, whether corrective or preventative, to address any known or obvious conditions. So I said corrective or preventative because they can be different. Again, for example, a situation where we need to order materials in order to really correct the condition, we can prevent access to it. And that might be by barricading the area or blocking off access to it. We want to make sure that we take that action as soon as we become familiar with the condition. And that might be some condition that is just observed or it's reported. Also, if we get a series of citations from MSHA, we want to take a hard look at, are we getting a bunch of citations on housekeeping? Then we probably want to be looking at our housekeeping procedures and making sure that we're really coming down on that with an area of emphasis on our own, because you can be taken as, hey, you knew or you should have known of this. We've issued you a bunch of citations. You also just want to have yourself as a manager or your employees as well be paying attention and have a good system of communication. I know that is fundamental, but so many of these issues can be cut off if we just had a quick and easy means of communicating them and taking some action on them. Now, a lot of this is going to be brought up when we look at obviousness or when we look at knowing about it in the evaluation of hazards on our workplace exams. But this also applies to work practices. So make sure that we are looking at what's going on there. Lastly, a big issue with this is the review of termination and abatement timeframes. Make sure we're looking at these, because if you are not abating things, not only are you, after MSHA issues a citation, you're not only going to be putting yourself in a position to receive a failure to abate, a 104B, but you are also putting yourself in the area where you can receive that subsequent 104D and get further down that rabbit hole. So make sure you're aware of them. If there is unfeasible or technically, financially, make sure that the abatement that is discussed with MSHA, you can seek extensions to abatement timeframes, but make sure that's somewhere that you're paying attention to. Another area that is incredibly important when we're looking at unwarrantable failures is statements made to MSHA. So I would say that the vast majority, probably 80% or more, maybe even higher than that, of unwarrantable failures are based directly off of admissions against interest provided to the inspector by an agent of management. What do I mean by an admission against interest? It is just an off-the-cuff comment saying, oh yeah, that's been like that for 3 months, or that's been like that for a week and a half. We've been running really hard. We haven't had a chance to fix it yet. Well, you just demonstrated, 1, that you knew about it, 2, that it's existed for an extended period of time, and 3, that you put production over safety. That is going to be an unwarrantable failure. So you want to be guarded, or at least considerate of what you're saying during an MSHA inspection. And I know that, again, somewhat goes as common sense, but it is incredibly important, because most of these unwarrantable failures that we find are based off supervisor statements. Again, both laborer statements and supervisor statements can lead to an unwarrantable failure, but supervisor or management statements, if you are an agent of the company, most definitely bind the company. So if you as a manager admit to knowing about the condition that wasn't corrected for 3 weeks or 3 months, the company just admitted that. And you're not only going to be satisfying the requirements of an unwarrantable failure of the company, but you're also going to be probably standing in line for a special investigation that we'll talk about next into agent liability. Also, hearsay is admissible under the Mine Act and before the Federal Mine Safety and Health Review Commission. So this means even if you want to go back later and say, I did not say that, I was taken out of context, the inspector can sit there on the witness stand and testify that you told them that you knew about that condition for 3 weeks. So now you're in the position that you have to provide evidence that that wasn't the case. So it is incredibly important that we are thoughtful in our discussions with inspectors. We try not to let our emotions get the best of us and make a comment that we regret either immediately or much later on. But this is an essential element because it comes up so often in the process. And especially if you're an agent of management, what you said is going to be included in that description or that description of the events on the citation. And you'll also be set up nicely in MSHA's eyes for a supervisor liability investigation. And so this is under Section 110 of the Act, and it grants MSHA the power to investigate and pursue both civil and or criminal penalties against agents of mine operators. So to be an agent, it means you have to be involved in instructing the workforce. Do you have the power to hire and fire? What is your job title? You know, it is not a one-size-fits-all evaluation. You have to go through each element. But typically, if you're going to be considered a foreman or a superintendent or a general manager, or say a health and safety director or something along those lines, you're going to be considered an agent management. And therefore, your comments will bind the company, and you will also be subject to this kind of liability. It's important to note that criminal violations are very rare. I think everyone probably is aware of the big criminal prosecution last year against Blankenship down in West Virginia. There are very few of those. They get a lot of attention because they are so rare. Nonetheless, it is something we need to be aware of just because it's out there. In those situations, you are typically having falsified records or lied to the agency or directed someone to do something egregious, such as force them to operate a piece of equipment that does not have service brakes operational at the time. Those very, very high level, we know what we were doing was wrong and we did it anyways. A much lower bar, though, is civil penalties issued against agents. And so in this case, after a special investigation, MSHA would determine that they are going to issue an additional penalty, not against the company, but against the individual agent. And again, these are contestable, just like any other MSHA citation, but essentially the biggest element is they are investigating how much the agent and management knew, what their position was in the company at the time of the occurrence, and if they were in a position to protect against this hazard. You are going to go through this special investigation. They are drawn out, they are arduous, but you will have a separate investigator than the issuing inspector show up. They will want to conduct interviews. They might have document requests. Just know that if you are a supervisor, you are still a minor, and therefore you have the same rights as minors when it comes to interviews with MSHA. And again, you have to consider what's going on, who's the subject of the investigation. But my recommendation would be, as a supervisor, you think long and hard about sitting down with MSHA to give an interview without representation present or without discussing the situation with representation prior to. But as a supervisor, you have the same rights as any other rank and file minor on your property, and that is you have the right to refuse to be interviewed by MSHA during an investigation. You have the right to sit down with MSHA and be interviewed as much as you want or as little as you want. You also have the right to have any representative you want sitting in the room with you, whether that is an attorney, your best friend, your supervisor, whoever it might be. I will say, during the special investigation, though, the interviews will likely include both management and non-management personnel. It's important that all minors know their rights when it comes to what's on the screen right now. And also, but you cannot force any element of these on them. Do not force your personnel to refuse an interview with MSHA. Don't force them to sit down with MSHA and tell a story that you think is helpful. Also, for your minors, MSHA won't like this, but they do have the option of having management sit in the interview with them. They just have to make that expressly clear to MSHA that you did not in any way force them or coerce them into having you be their representative. So I will say be incredibly careful if you are delivering notice to your minors that an investigation is going to be conducted. If it's a client I'm working with, or a company calls me and says that they just received a 104D, or they might be subject to a special investigation, or a special investigation has begun, I will send a written notice from me outlining these very brief and very important rights, so that you're not being misinterpreted by an inspector as to what you're telling them, and that you are trying to persuade people against complying or working with MSHA. So just be aware, though, that these apply not only to every employee or minor on your site, but also any supervisor. that is important. Other best practices is if there is an unwarrantable failure issued, the supervisor that is named either on the top of that citation or in the body of the citation, to the extent possible, and I know it isn't always possible, should try and sit out the rest of the inspection. And that includes the closeout conference. And that's because any statement made moving forward could be, piled on as the basis for a special investigation or increasing that negligence designation. So again, this is why, when I talk to companies, I always recommend they have multiple persons trained on how to accompany an inspector during an inspection or to work with MSHA. But if this is something that you can swing in terms of having that person sit out after a 104D is issued, you most certainly should do so, in my opinion. If it is a foreman that's named and you can have the safety person continue on, that's fine, whatever your situation might be. But that is a recommendation. The person that is named, you might not get that written citation immediately, but the inspector will typically be able to tell you what they think happened. And you can ask them, why are you issuing a unwarrantable failure? Who do you believe was involved from management that knew of this? And you can go from there. You can ask some questions before it's actually put on paper so that you can best safeguard yourself and the company moving forward. If there is a 104D issued and you're a supervisor on site, be prepared because you're going to be questioned during the investigation and probably subsequently. All of the 104Ds that are issued are reviewed for agent liability at the district level. 5 years ago, you didn't see very many agent investigations. At the tail end of the Obama administration, MSHA, you saw almost all 104Ds issued have an accompanying special investigation. It was a very, very high level. Well, not all, but nearly. That has really continued under the Trump administration of MSHA. I will say, in my experience the last year, they have been, they being MSHA, more willing to hear us out as an operator and dismiss an agent case if you provide the necessary reasoning. Whereas before, I think they would just push it through, assess a penalty, and let you try and litigate it out. I've had more cases thrown out at the district level, but nonetheless, they are still conducting the investigations. And as with any MSHA citation or speeding ticket or parking ticket, it's easier to defend before it's written. So the investigation time frame is incredibly important. If you can cut off the investigation at that time and provide reasoning why a specific agent of management wasn't negligent or didn't have aggravated conduct, great. Also, knocking out an agent liability case at that time or at any time, if you are contesting the MSHA citation as a company, is helpful because now you're not taking that case before a judge or taking it before a solicitor and also having to argue that this specific agent was not negligent. You just get to argue that the company did not know or the company did not satisfy the requirements of an unwarrantable failure. So be aggressive in defending against a special investigation. Always be willing to tell MSHA you don't wish to speak with them if that's your choice. And if you do make a statement and you sit down and you have an interview, do not sign anything unless you are absolutely sure it is 100% accurate. And I mean down to every comma, every proper punctuation, everything. Because as soon as you sign a document during a special investigation, you have attested to the veracity of that statement. MSHA inspectors, even if it's typed up, are not stenographers. These are not 100% accurate statements. They are summaries and notes of what they just heard. This is a really important one. If you have signed a statement as a supervisor, as a target of a special investigation, and admitted to anything in that statement, it is very hard to fight it from that point forward. So if I was sitting down with any agent management I am representing, I would tell them do not sign. That is my recommendation in terms of that, because you don't know that it is entirely accurate. I had a company at one point in time during an investigation, an investigator did an interview, and he asked the minor to sign his notes to claim that the interview was accurate, and we asked him to read his notes back to us so we could determine if it was correct. The inspector couldn't even read his notes that he wanted us to sign and say we're accurate. So again, be very protective of this. In terms of other recommendations, these are long, these are drawn out as I talked about. They can last months to years. A special investigation might not even occur for months after a citation or order is issued. You most likely won't hear from MSHA for a long period of time. And as I said before, be aggressive in defending it, and if there's a simple answer, provide it and stick with it. One of the worst things that we can do is attempt to appease an investigator, tell them what we think they want to hear. And by doing that, we make an assumption or we guess. And then our story changes because we're taking it down different routes of what may have happened or what could have happened. So stick to what we know, stick to what is true, and you provide that to MSHA. Don't indulge questions of what if or what may have been. Just stick with what you know and be outspoken about the safety and health practices that you and the company employ. If you have a robust safety system, if you have checks in place, if you took particular action in this type at this time to protect against a specific injury or a specific condition, make sure they know that. Make sure they're aware of that defensive information. So to cap off the supervisor, if you're going to be subject to a special investigation or if a 104D is issued, my suggestion is engage some legal counsel, whether that is an in-house counsel available, outside counsel such as myself or other attorneys. Engage them, review the situation, because they might be able to tell you how aggressive we need to be, what your liability possibilities look like, and how things might change, whether that is your abatement timeframes or the specific liability for an agent. 104Ds, as we've talked about, they shut down your operation. They're hard to get rid of. They're hard to appease MSHA. And one area that I have seen MSHA become more stringent in the last couple of years is their requirements for lifting or terminating a 104D withdrawal. They are making operators jump through hoops. Write a new section of your manual. Task train everybody about it. You have to be willing to push back on that, but in a way that is not going to make the situation worse. So talk to someone who knows what's going on. Maybe that is even a senior safety personnel or regulatory specialist in your company. Document your recollection of events. I will say, preferably after speaking with an attorney who requests you to do so under privilege, as I would do if you called me. If you document your recollection of events and it's not at the request of an attorney, that is going to be a discoverable document. So just be careful what you put in it, that it is nothing that will come back to harm you later on. If you get told or requested to do that by an attorney, it would be protected attorney work product, and you could maybe be a little bit more liberal in what is included. But if you write anything down, and this goes for any inspection, but especially when you're in the 104D with the possibility for agent liability, if you're going to write down your notes, your recollection of events, be very careful about what you include in that, because MSHA can get that later on if you're litigating it. I would, and then the overarching, never, ever, ever do this. Do not ever attempt to dissuade or persuade employees from working with MSHA, communicating with MSHA, creating dialogue for them. That comes out, and that makes every situation 100 times worse. So that is just some high-level supervisor recommendations that we need to talk about, because it is one of the most problematic or effective results of a 104D is these agent investigations. So remember that the 104Ds have different types. Each type has a different consequence. All of them can lead to a supervisor liability action. So you don't need to wait for a 104D2 to become protective or defensive on that end. Start when you get that initial D1 citation. The penalties are higher, but probably the most concerning element for you as an operator is the withdrawal order capabilities of each of these, or of the 104D1 order and 104D2 order, because they can really shut down your operation and can be very difficult to lift. So be careful with those and make sure you pay attention to any time one of these gets issued. I would also recommend that you, as a company, contest any 104D that's issued, just because there might be a subsequent agent action that you're not aware of for months. And then by the time that agent action gets started, the company's already paid it and you are kind of behind the eight ball that the company has admitted that an unwarrantable failure occurred by paying that. So a bit more on the recommendation side there. But I want to thank everyone for joining us today. Just a reminder that you can still check out the blog at the MSHAdefensereport.com. We'll post this webinar as well as the recording there in the next couple of days. I want to thank everyone who joined us for the 2018 series. I appreciate you getting on here and taking the time out of your days to talk about MSHA with me. I will be releasing the 29 series shortly. If you are going to be participating again and you have any topics that you would like to hear about, I welcome you to put those in the post-survey or the post-webinar survey comments. I'm always looking for topics that are going to be look forward to and beneficial to the audience. So let me know if you have any suggestions on that end. I'm happy to take any more questions right now. And I actually see one popped up. Does MSHA have a right to come to your home during an investigation? Yes, MSHA can. And often this is a tactic that we see them use, especially with non-management personnel. One of the first items that is always requested during a special investigation and that companies must provide to the agency is a list of the contact information for the minors that are either on property or involved in the situation which led to an unwarrantable failure or the topic of the special investigation. And typically, MSHA will try to conduct some interviews on site, but it is also very common for the special investigators to go visit minors at their home or call them on their personal phones. And it's okay to make the other people aware of that. Their same rights apply. They can tell them to leave or they don't want to talk with them. But it is, of course, more intimidating when someone shows up, puts their MSHA special investigator badge up next to the door, and tells you they're there to talk with you. But the same rights do apply. But yes, that does occur, and it can occur. Another question is, if you are the subject of a special investigation and you leave the employer that you're with that is under investigation, can they follow you to your next job? The agency, as a target of investigation, yes, the investigation can follow you to another job, especially if that job is still in the mining industry. If the job is no longer in the mining industry, that is information that you want to provide to the agency immediately because that can influence their decision to pursue action against you because you're, again, MSHA citations, MSHA fines are meant to be punitive in nature, so punishing people or companies for failing to follow the law. If you are no longer going to be in the mining industry, that somewhat loses its effect, and it can be an element that you put before the agency to quit the investigation. If you are not the subject or target of an investigation, but MSHA still wants to talk to you as a witness, yes, they can also follow that, and they will have your personal information. You can make them aware that I'm no longer with the company, I have nothing to do with this, but they might nonetheless still contact you in order to elicit some kind of conversation. But your rights still apply that you don't have to cooperate with them, you don't have to speak to them. That is up to you. All right, well, I hope that answered those questions, and I hope none of you ever get in that situation. If there aren't any more questions right now, I appreciate everyone jumping on the line. If there are questions that come up at a later time or something that you just didn't want to bring up today on the webinar, feel free to call me or email me or contact me by any means that works for you, and I'm happy to discuss any of these elements. So with that, I don't think we have any more questions, and I want to thank everyone for joining us today, and have a great rest of the week.